Hey, Ellen, can you hear me okay?
Yes, do you want to go ahead and start your screen now? And we've got 1 minute. We've got a few people out there. We'll get started. There we
Okay.
go. If you can
Can you see
also,
my screen right now? It says I'm screen sharing.
yes, we've got you. All right.
Perfect.
Welcome this evening. We have Rachel Broughton from the Florida Healthcare Law Firm. They are a law firm that has offered FASOMA free consultations for our members and also reduced rate on legal fees. And Rachel is our main contact there now. So we're very happy that she's here. This webinar is being recorded and will be available to people that signed up for it. So we'll go from there. Thank you, Rachel, for being here and helping us explore House Bill 197, because some of us do have a massage therapists in the office and we need to take a look at that. So thank you.
Yeah, absolutely. Good evening, everyone. And my name is Rachel Broughton. As Ellen said, I'm one of the attorneys here at the Florida Healthcare Law Firm. Thank you all for attending tonight. Thank you, Ellen, for the introduction. I'm going to do my best to keep my portion of this presentation brief and open it up for a discussion and question and answer session. Um, so I'll tell you a little bit about myself and our law firm first. We regularly represent healthcare providers and businesses of various forms with regulatory compliance, transactional, and overall operational and business guidance. So if you ever, as Ellen mentioned, we do offer for FASOMA members a free 15-minute consultation. So this presentation is just an example of, I'm going to provide you with general legal guidance today, purely for informational purposes. But in order to really get an in-depth legal analysis that pertains to your specific business, we would first need to go through a formal attorney-client engagement process. So with that being said, I'm going to get started. Again, my name is Rachel. I represent healthcare providers of many types, including acupuncturists. I've been doing this for about 5 years, and I am always keeping up with, the latest legislation and how that's being interpreted and enforced. So I was excited to get started on this project. So what many of you may already know is that the House Bill 197 that governs massage establishments was signed into law in April of 2024, the effective date being July 1st, 2024. And for purposes of summarization, we're not going to focus too much on what the new law requires, more so how it applies and what its scope is. Essentially, the House Bill 197 implemented some additional record keeping requirements to licensed massage establishments and individuals that are associated with such establishments. Um, Here's a little summary right here of what those requirements are. I think the main question today and the objective that we're going to focus on is, when do these requirements apply to me and my business? Simply by being affiliated with a licensed massage establishment.
Rachel, I'm not sure your slides are advancing.
Okay, let me see here. Ellen, can you, are they advancing now?
No, we're just seeing the very first House Bill 197 examined.
Okay, I apologize. Let me stop sharing my screen and then reshare. Maybe that will resolve the issue. Ellen, how is that?
Sorry,
That's better, Rachel.
yeah,
Are we
that's,
moving
there we
along
go.
now?
Yes, yes.
Okay. I apologize. I don't know what happened there. Okay. So we were talking about a little bit of an overview of what the new statutory requirements are. And it basically boils down to some additional employment and patient record keeping requirements. I've outlined those here for your review. I think for purposes of today's conversation, we're going to focus more on the scope and how far of a reach this new statutory guidance has on licensed professionals such as yourselves.
So these requirements are for the LMTs, is that correct?
Yes, that is correct. And what we're
Okay.
going to get into in a little bit more detail is that the new statute does sort of expand some definitions that do apparently reach to licensed healthcare professionals, depending upon the specific nature of their relationship with an LMT that essentially operates under a massage establishment license.
Thank you.
So in summary, House Bill 197, as I was explaining a little bit earlier, does broaden the definition of a few important things. The first is a designated establishment manager. The second is employee, and the third is the sexual activity. For purposes of today's presentation, we will be focusing on the designated establishment manager and employee definitions. So basically, our objective today is to identify and discuss the relevant factors that might assist each of you in the determination of whether the new record keeping requirements apply to you and your businesses who engage with licensed massage establishments. I know one common question that was posed that Ellen had sent over to me was that many of you either sublease space to an LMT or you sublease space from an LMT. So both of those, that's definitely an important question. And hopefully after, the end of this presentation, we have a little bit of a better idea as to what your given situation is and where you fall. Okay, so as I mentioned earlier, the definitions are essentially the key concepts here. So the definitions changed and basically reach a little bit further to potentially affect some of you that are here listening. The definition of a designated establishment manager, which is someone who would fall within these, I'm going to say, additional record keeping requirements, is a massage therapist who holds a clear active license without restriction, and now also a healthcare practitioner licensed under Chapter 457, such as many, if not most of you, that who is responsible for the operation of a massage establishment in accordance with the provisions of this chapter, and who is designated the manager by rules or practices at the establishment. Now, this is an important revision because it essentially says that if you are a healthcare practitioner and you are basically designated the manager of one of these massage establishments, that you do fall within the scope and reach of these requirements and regulations. And we're going to talk a little bit more about this later on in the presentation, but just as sort of an introduction and an overview, these are two key definitions to keep in mind throughout our discussions this evening. The second definition that is important for purposes of our analysis and discussion is the definition of an employee. House Bill 197 broadens the definition under the statute to include independent contractors and lessees. I put the exact verbiage of the statute here that employee means any person, including but not limited to independent contractors, or lessees of a massage establishment whose duties involve any aspect or capacity of the massage establishment, including but not limited to preparing meals and cleaning, regardless of whether such person is compensated for the performance of such duties. Now, this definition, I think, is what has sparked the most confusion. It's very rare that you see the definition of an employee include independent contractors. That's a legal discussion for another day. But it's interesting for purposes of our discussion this evening, because it does appear that the scope of this statute is meant to reach pretty broadly. So without going into too much detail, I want to give all of our attendees tonight a little bit of a background as to how to approach something like this when a statute is a little bit ambiguous. So when we were talking about the definition for an employee, as with respect to, who does this apply to? Does this apply to me? Am I considered an employee? Is my, front desk reception staff or billing staff going to be included as an employee within the means of this definition? It's a little bit unclear how the professional board and the state of Florida is going to interpret this. Um, Basically because it's not clearly defined whose duties involve any aspect or capacity of the massage establishment. So any aspect or capacity of the massage establishment could be interpreted in many different ways. Um, so basically what happens in Florida when a statute is a little bit ambiguous and not so clear, you basically have to rely on the judiciary to interpret the statute before you can, fully rely or understand how the statute might apply to you. In many cases, there are situations where a statute passes and then you see the various professional boards that are involved. They start to issue some piecemeal guidance, providing some more clarification on the issue. So I'm hopeful that that will come about. I'm not hopeful that it will happen quickly. But usually we have to sort of interpret the statute, prepare ourselves and your businesses for, what enforcement or regulatory scrutiny might come from this, and adjust accordingly as we receive additional guidance. So based on the statute, and I've shared a link of the actual verbiage of the statute here at the end of the presentation for everyone. But what the statute does make clear is that if you have a licensed healthcare practitioner in question, and that individual is deemed the designated establishment manager for the massage establishment license, and that person is responsible for the operation of a massage establishment and is designated the manager of the establishment, these record keeping requirements are going to apply to you. The statute makes that very clear. And then so the next one would be the licensed healthcare practitioner in question holds duties that involve any aspect or capacity of the massage establishment. And that includes preparation of meals, cleanings, regardless of whether they're compensated. So this is where the ambiguity comes in, and what we're going to talk a little bit more about next. Basically, we're going to talk about some factors and a totality of the circumstances consideration to see if your relationships with these massage establishments fall within that realm of any aspect or capacity. And then lastly here, the verbiage of the statute does make it clear that an independent contractor and sublessee is included in the definition of employee. So just because someone's an independent contractor or classified as one does not remove you from these additional record keeping requirements. and same with a sublessee. Okay, so one question that I think is important to consider when conducting this analysis with respect to your specific business model is whether the licensed massage therapist duties and operations serve your as the non-LMT practice or provider. How does it serve your business? Does the does the license does the LMT's operations and daily activities affect your business? What level of interaction goes between the two of you? Do you share office staff? Do you interact regularly? Are your is the premises rented out basically in separate rooms? What level of interaction? If the LMT's duties and operations do somewhat serve the non-LMT practice or you as acupuncturists, you should probably treat the whole as an employee for purposes of the statute's interpretation. Um, Now, if the LMT maintains independence from your practice, depending upon the degree of independence, then the LMT would likely not be considered an employee and vice versa. And I think the record keeping requirements would not apply. Now, keep in mind that the statute does say that basically being an independent contractor is not enough. So that's not independent enough for the state. So we're going to talk, and again, this is a little bit of a gray area, but what I'm going to do here this evening is provide you with a few factors to consider. You know, how independent are we? Are we considered, intertwined? Or do our duties and operations kind of serve purposes for each other aside from the sublessee sublessor relationship? And then, you can make an informed decision with crunching those factors. Okay, so the most important question to ask yourself is, to what extent do these two entities interact? Does the licensed healthcare practitioner regular activities involve any aspect or capacity of the operations of the massage establishment licensee? Here are some of the factors that I think are important to consider in answering this question. Um, so, are there two separate and distinct entities that are sharing an office space? Do these separate and distinct entities have a sort of landlord and tenant relationship, or is there some sort of business relationship between the two? Another common one, I think, that additional record keeping requirements may not apply to you if you have separate and distinct personnel, operations, signage, internal policies and procedures. Basically, if you are operating as two distinct entities as opposed to one cohesive business. Now, another important factor to consider, and is probably my biggest piece of advice for those of you who are interested in, you're either the sublessee or sublessor, is to take a look at your subleases. Make sure that they're carefully drafted to outline the terms of the relationship between yourselves and the massage establishment. Now, the reason for doing this is because there is a little bit of a gray area, and if and when regulatory enforcement does, surface, you want to make sure that you have as much documentation as possible and that you have policies and procedures in place, essentially to show the state, hey, you would have a good faith argument that, your business's regular activities don't really involve any aspect or capacity of the operations for the massage establishment. Now, the way to do this is, again, first and foremost, I think with the sublease relationship, the terms of that sublease agreement are going to be very important. You want to make sure that the duties of each of the entities and the personnel involved are clearly delineated and distinct in that sublease agreement. You want to make sure that this is in place before you have a regulatory authority knock on your door or request information. That way you have documentation, policies, and procedures to show, hey, no, look, we actually are, very distinct. This is how we operate. It's a typical sublessee, sublessor relationship. There's no guarantee with the state that that would in and of itself save the day, but it's certainly one recommendation and compliance measure that you can put into place to prevent any unwanted regulatory scrutiny. Now, another recommendation that I have is to basically prevent there from being any, if you want to remove yourselves from these additional requirements, it's going to be best to ensure that there is no crossover of operations between the two entities. So again, just making sure that it is a sublessee, sublessor type relationship. I know, again, none of these are really going to make the day, but I think it's more of a totality of the circumstances sort of analysis. Um, if you share front desk reception or billing personnel, I think there's an argument that, that's an aspect or capacity of the operations of the massage establishment license. Um, and at a minimum, the individuals involved would be considered an employee within the meaning of the statute. So we talked a little bit about documentation and its importance and basically how the statute's going to be interpreted and enforced moving forward. Some additional levels of documentation and compliance to consider is the operating agreements for the entities. You want to make sure each entity has its own operating agreement that identifies its ownership structure, the duties and responsibilities of each owner or operator of the business. This is just another piece of documentation that if and when the state examines a given relationship, you have documentation to show that these are actually, separate and distinct entities. They are not your entity being the licensed healthcare professional. You're not really involved in any aspect or capacity of the massage establishment license. And now, another thing to consider here is not only those of you who are already in these relationships, but those of you who are presented with opportunities to affiliate yourselves. I think requesting from the massage establishment in advance that they provide you with these materials is another, I think that's another important and very significant thing to do moving forward. Now, I think the last thing is having policies and procedures in place internally that basically designate the responsibilities that both you and the massage establishment licensee have. It's another form of documentation, again, that if the state were to come in, you can provide them with that. And you have policies, procedures, and then ongoing proof to show that you're abiding by those policies and procedures. That can also be very helpful. Another one I think is notifying patients of the distinction between the two entities or the two providers. This can be easily incorporated into the patient intake process, where you would essentially disclaim or notify patients. I think oftentimes the state, when they're interpreting and enforcing statutes such as this one, they look to, well, how are they holding themselves out to the patient? What does it appear, to the average layperson? They may know that it's just a landlord tenant type relationship, but do the patients know that? Is that ascertainable by the public. So another, measure to consider would be to, conspicuously notify the patients, hey, we operate separately and distinctly, and that's sort of another item to consider. So I put together a few hypotheticals here, and these may or may not apply to you. And I think when we get into the discussion, we'll be able to get into a little bit more specifics. But basically, hypothetical number one is you have an acupuncturist who subleases space from an LMT with a massage establishment license, and the acupuncturist shares front desk staff, billing staff, hours of operation, and signage with the LMT/massage establishment licensed entity. In this hypothetical, it appears that the additional record keeping requirements would apply universally to both the acupuncturist and the LMT massage establishment license permittee. Now, this is because of that. Again, there is a pretty large, a very convincing argument here that the acupuncturist is involved in the operations and the business, and they do share and interact a lot. Now, this is to be differentiated from hypothetical number two, where you have a licensed massage therapist with a massage establishment license, and they sublease a space from an acupuncturist with separate signage, separate reception and billing staff, separate governing policies and procedures, the documentation that we discussed earlier. The non-licensed massage therapist and its personnel are in no way involved in the day-to-day operations of the massage establishment licensee. Now, under those circumstances, I do believe there's a good faith argument that the record keeping requirements would not reach to the acupuncturist or the non-LMT under those circumstances. But it is a little bit of a sliding scale analysis because we don't have that, hard interpretation by the courts or by the professional boards. So really at the end of the day, and of course I'm going to open this up for discussion, but it's really a sliding scale. And oftentimes I always tell my clients, it's what is your risk tolerance, right? What is your risk tolerance for any level of regulatory enforcement? The lowest, if you find yourself on the lowest end of that spectrum, I would recommend that you start implementing the policies and procedures, and you bring your business sort of under the scope of these licensed massage establishments and abide by their record keeping requirements and things like that. So, that's the best way to avoid the risk, right? Now, if you have more of a moderate risk tolerance, I think taking some of these steps that we've discussed here today, by sort of taking a look at, okay, how intertwined are we? Do we share just office space? Do we share staff? Do we share signage? Do we operate distinctly? Making sure that you implement not only in terms of the relationship, but documentation. I think that would be my recommendation for a client that is willing to go, a little bit more moderately. Now, in this space, again, and as we've discussed early, the high risk is going to be you do operate together as more of a cohesive practice, and you hold yourself out to the public that way. Then you really need to be abiding by these additional record keeping requirements if that is the case. So the key takeaway for today is that compliance with these record keeping requirements hinges on these new definitions that the statute has brought into play. Even though these are some factors and some compliance measures that can be implemented to reduce any amount of regulatory risk, It is extremely important to examine each relationship carefully. I highly recommend you speak with an attorney who is well versed in reviewing this type of documentation. So, the operating agreements, the sublease agreements, policies and procedures. All of these things are, it's again, it's a totality of the circumstances and case by case analysis to each relationship and each, business and sublessee, sublessor structural arrangement. Um, I think the final thought here, and again, I feel like I'm really drilling down on this, is the documentation piece. Sometimes when I make these recommendations to clients, it seems a little bit redundant. Like, well, what do you mean? I have policies and procedures. Policies and procedures are probably the most important thing when it comes to regulatory enforcement in any respect, and oftentimes are overlooked by providers as, again, seeming a little bit silly. But I can't stress enough the importance of having these, if not only for smooth business operations, but certainly to be prepared if you ever are questioned by a regulatory authority or the various professional boards. You have that documentation to provide. So that is basically the end of my presentation and what I've prepared for you this evening. Ellen and I had discussed that most of you were interested in more of an open discussion, a Q&A. So I would like to go ahead and open it up to you. Ellen, if that's okay with you, I would like to open it up to all of the attendees.
Yeah. If people want to move the presentation over a little, you can grab, there's a bar in between the picture of the speaker and the presentation and move it over and go up and do gallery view. Then you can, oh, I guess, Rachel, you need to turn your camera back on.
Oh,
We do have a question in the chat. What are the new record keeping requirements? Are they patient keeping record requirements? That's one question. And if
okay.
people want to ask verbally, there's a way to raise your hand and I can call on you and unmute you, or you can put a question in the chat or the Q&A. But that's the first one, is what exactly are the new record keeping requirements?
Sure. I have those outlined here in the overview slide. Again, this is a very brief overview, but essentially it requires certain employment records and patient records. So for the employment records, the required information it's basically just to keep an employee personnel file. Now, the interesting thing here is that the requirement does come into play before any service or treatment is provided. Now, considering the bill became, effective on July 1st, I think this is something that you're going to want to do sooner rather than later. But it seems, again, and we go back to that risk tolerance and analysis, and the employment records are something that virtually every healthcare business or massage establishment should be doing anyway. This statute just sort of adds an additional layer to it. And as for the patient records, that's here as well. And again, this is just sort of a very brief shorthanded outline of those requirements. I've included a link to the actual the list in the statute for reference, so that can be found here as well.
Can you send me your PowerPoint? I can make a handout of it and share that with people so they have that link.
Yeah, absolutely. I'd be
Okay.
happy to.
Okay.
I'm reluctant to turn my video camera back on because I think that was the issue with my PowerPoint not showing up.
Oh,
Um,
okay, no
so
worries.
if that's I don't want to I would rather you be able to see the references in my presentation.
Sure. Um, I'm going to give you a situation. Uh, a practice is owned by a physical therapist and his wife run it. They have the massage establishment license, but they also have a medical doctor, uh, the physical therapist, an acupuncturist, and a massage therapist sometimes too, working there, all on a contract basis, well, except the physical therapist that owns it. So generally, I would say, I'm going to assume they would all have to follow the new record keeping requirements.
Without, based on the amount of information provided, I would agree. Because assuming they're operating under a massage establishment license, um, I would err on the side of caution here and answer your question as yes. The To me, if it's one entity and they're operating as various different providers, so they're sharing probably administrative staff, there, as we know from the statute, there is no independent contractor exemption. So the fact that they're just contracted doesn't really convince me otherwise. So my answer to that would be yes, that would the requirements would apply universally to the physical therapy owned business.
We have a question about this sounds like it is not HIPAA compliant because of having to have records available.
That's a great question. So one thing that when you enter into these types of relationships, oftentimes sublease agreements, um, you want to enter into something that is referred to as a business associate agreement. This is an agreement that would be between the two entities to basically detail that there is HIPAA compliance, and that one party may receive access to information from another party, and essentially just lays out the privacy policies between the two. So that's the way to, abide by the statute, but also make sure that you're staying HIPAA compliant.
I'm just going to ask, this may be referring to the person coming into the office to inspect it for the state having access to records. Is that, I'm not sure if that's what she meant. That's what I was assuming she meant.
Oh,
Let's
okay.
see.
I think for purposes of, looking at it from that lens, there is, and this depends on what state you're in. Sometimes it depends on the county. But there are certain exceptions to the general HIPAA laws, that basically say that a governmental entity has the right to examine records. So there is a carve out for situations that involve government agencies, and basically allows them to investigate and use a tool of documentation requests and information requests at their disposal.
Okay. Any other people have what ifs or situations they want to talk about? Let me know. I can let you talk or you can type it in. If you have Kim raised her hand, let me let Kim talk. She may have some clarification. You should be able to unmute yourself, Kim.
Yes, can you hear me?
Oh, yes.
Okay. So I lease from a massage therapist. She leases to another massage therapist and she leases to me. we each have different corporations or, LLCs or whatever. We do not have any employees between us. We all run our businesses separately. We all have different legal names for our businesses. We all have our own websites. We don't share any information between each other. We don't share any scheduling between each other. We just have we share the bathroom, and there's a little small, little reception area. And, we take turns cleaning the bathroom and the reception area. We don't clean each other's offices. None of that. I don't keep my records there. I keep them at home. If I am at work and I have to leave, I lock my door. I don't allow them to, see my records. So for me now, so what the two licensed massage therapists are doing is they have a book now, and they put in this book each of their, basically the schedule, the name, the address, the phone number of the patient, of their clients, what time they came in, blah, blah, blah. To me, if I was to give them that information, that seems to me that that's not HIPAA compliant. Like it seems to me like I would have to say to my patients, look, the state wants this information from me, and it's going to go in this book, and it's going to have your name and your phone number and what you came in for and all of that. I mean, that to me does not sound HIPAA compliant, because I'm giving these other people, these massage therapists that I don't have anything to do with, information on my patients.
Right. Okay. Thank you, Kim. That is a very legitimate concern. I think my response to that would be based on the factors that you described. You basically touched on kind of each of them, that you operate very distinctly. Now, I would say, based on that, I think there is a good faith argument that you would not be considered involved in any aspect or capacity of the massage establishment, or the licensee. Now, if again you wanted to reduce the risk and abide by these additional record keeping requirements from a HIPAA standpoint, here's what I would recommend there.
Okay.
Basically, what the first thing would be in your patient intake process. So when you're having an initial patient exam or conducting an initial patient exam, you would want to make sure that your documentation identifies to the patient what your privacy policies are. Now, with these specific factual circumstances, and most privacy policies do this, but it's really important that you would take a look and make sure. As long as your patients provide informed consent to you, that they're aware of what your privacy policies are, that you might share their information under certain circumstances, you would basically address this there. So there's usually a portion that says, if requested by a government authority, I am entitled to share your information.
Well,
And then the other one.
I have that in my consent, but I don't, but this is the man, sort of the designated manager is a licensed massage therapist. She's not a government employee. So she's the one that's taking this information from me and putting it in a book and having it available for the inspector. So she's not within I mean, I'd have to put her in as a person. Do they consent to having her having their information? Is that?
Right. Yes. So the government agency part is if the government were to come in and request documentation. Now, that how you take care of the situation where if you were to share information with the massage establishment manager, you would have to take a look at your privacy policies, make sure that you notify patients and that they provide informed consent that you will share their information with business associates or third parties for purposes of abiding by state and federal law.
Oh,
So that's something else that you'll want to kind of take a look at and revise your privacy policies accordingly if
Right.
you know, intend to change things.
So let me ask you this. Could I do my own sort of book? Um, I mean, we're not all there at the same time. I mean, if they came in, well, I was just going to say, could I have my own, information separate? But if they come in and she gives them the information, my information won't be there if I'm not in the office at the time. So I was just wondering if I could do mine separately. And if he came in and I wasn't there, then I'm not there. If he comes in and I'm there, I could show it to him. I mean, I don't know how that would work.
Right, right. I think under those circumstances, I don't see anything wrong with, you know, we have to talk about this is the statute that governs the massage establishment
Right.
and the licensed massage therapists. So if and when there is you know, increased enforcement of this statute, the first place they're going to go is to the LMTs,
Right.
right?
Mhm.
So, but you know, something that's important for me to point out is that if I were representing in your hypothetical that you just presented, the LMT, before I enter into any sort of agreement with an acupuncturist or a physician or someone else to rent space or either rent space from them, I would want some sort of contractual agreement to provide that information to me. Now, something else to look out for is in your agreements with them, sometimes there's a catch-all provision that says, you know, in exchange for the sublease agreement, you represent and warrant that you will do everything required of you by state and federal law.
Mhm.
So that would be, again, not necessarily would that put you as the target of an enforcement action, but you may experience a contractual dispute that results from doing so. Does that answer your question?
Yeah, I think so. I think so. Thank you. Thank you for your help.
Yeah, of course.
I'm a little confused because what I heard Kim describing was pretty much everything is separate. And so when you had those two extreme examples, um, she was on the side that would not have to comply. Um, you had the slide with the, um, everything separate, billing separate, book scheduling is separate, uh, website is separate. I mean, so I'm a little confused by the conversation at this point.
Yeah, I think just to clarify, and when Kim presented at first, you know, there's always, without having a clear definition in the statute or having, you know, guidance from the judiciary from in the courts, we have no way of knowing for sure that that type of relationship that Kim described is no risk. So there
Ah,
is
okay.
always a risk. I think all of the factors that she described with respect to that specific relationship, it's an extremely low risk area for enforcement. But that, you know, that's not to say that there's not a risk until we sort of see how this plays out. And again, in the judiciary, if the various professional boards come out with some additional guidance or interpretation of this law. But for now, it's more of a business decision and weighing that with, you know, what your risk tolerance is. Do you want to completely
Yeah.
eliminate the risk? And that's where my advice when we got into, well, what if Kim kept her stuff separate? If you're comfortable taking that risk, you know, it's a business decision. I have clients all the time that say, I'm okay, I just want to do everything I can to minimize the risk. I'm comfortable with, you know, it's more of a business decision at the end of the day. Not everyone can afford a no risk business model.
Yep.
Does that help?
Okay, thanks. That helps. Yeah. I have one I massage therapists, they just rent rooms and they have no personnel. Each massage therapist keeps their own records online. I have no access to them or their clients nor their records. So what is my responsibility? Can I release I'm not sure, and have each massage therapist gets their own? Oh, can I release my massage establishment license and have each massage therapist get their own? Can you have multi-massage establishments in one office? We only share bathroom and reception area. For now, we keep binder with their soap notes with client driver's licenses on it. All therapists have different work hours. There's a seminar in Jacksonville sponsored by the Massage Board to discuss inspection requirements.
Okay, so
it's in the chat if you need to look through it.
Yes, I see it here. Thank you.
Okay.
So there are several questions in here that I think are going to depend on other factors. I mean, the first, and I think most important question is if you as the acupuncturist are the designated manager of the massage establishment for that license, the statute makes clear that yes, this does apply to you and that you would be considered an employee for purposes of the additional record keeping requirements. Now, as far as all of the other stuff, like the other questions posed here, the massage establishment follows the entity. So I would want to sort of do a little bit deeper dive as to what the structure of these relationships are, what the contracts that are in place between each of these contractors, what the terms of those are. I think, you know, there are some factors here of distinction, but at the end of the day, it's a little bit unclear based on what's been provided here in the chat. It's difficult to give a precise answer without first looking at some additional documentation.
Deb, if you want to be able to talk for a second, just say yes in the chat and I can unmute you. There seems to be quite a few little angles on this whole thing. Okay, here, I'm gonna
Okay, I see. We have no contracts for 15 years, never an issue. Yeah, I would strongly encourage Deb to maybe revisit that. If not, you know, for ongoing business reasons with independent contractors, there are many healthcare considerations, and that's a conversation for another time. But I always recommend there be a written agreement in place between a business and an independent contractor, especially in the healthcare space because of the various fraud and abuse laws. And then, you know, for circumstances such as this that we're talking about here today.
Deb, if you want to say anything, you'll need to unmute yourself. Any other questions? Okay. Well, I certainly learned a lot. Thank you so much, Rachel, for being here and joining us and educating us. And your information's up here on the screen. I'll be sharing the video and the presentation materials with the links afterwards. And I want to thank you very much.
Awesome. Thank you, Ellen, and thank you everyone for attending. And yes, my email address and phone number is here. Ellen, I'll be sending you a PDF file of this PowerPoint presentation, so you'll have that to circulate to everyone who was unable to join us this evening. And yeah, if anyone has any, additional questions or wants to discuss a little bit further, just feel free to shoot me an email, give me a call. I'm happy to, as Ellen mentioned earlier, we do offer discounted rates for FASOMA members, and we also offer a free 15-minute consultation. So if you want to, set up a call to discuss your specific business model and your arrangement with a massage establishment, I'm more than happy to do that, and I love working with you guys.
Right. Thank you so much.
Thank you, everyone.
All right.
Have a good night.
I'll send out the recording tomorrow. Thank you, guys. Thank you for being members.